Right now, let's take you to the Supreme Court, where the constitutionality of the Anti-LGBTQ bill has come under deliberations. Enjoy.
You have it.
With respect. No, hold on, Mr. Chambers. Mr. Chambers, hold on. Mr. Abedu, hold on. Hold on. This is the affidavit sworn to by Mary Wendy Yeboah. Mr. Sorry. On the 2nd of April, you filed a notice of withdrawal of your affidavit in opposition. Did you or did you not?
We did, my lady.
Pardon me?
We did, my lady, but that
So the heading of that says, notice of withdrawal of first defendant respondent's affidavit in opposition to the plaintiff applicant's application for an order of interlocutory injunction filed on 15th March. So that is in relation to the application for injunction. This withdrawal of your affidavit in opposition is in relation to the interlocutory injunction.
Yes, my lady.
Thank you. Now so which affidavit are you referring to that has your preliminary objection?
My lady, yes, there's one filed on the 22nd day of, the first one was shown. Supplementary affidavit. Yes, my lady, we filed a second one that same day. The day of the same withdrawal. The timing my lady realized that that one was filed at 2:30. The first one.
Was at 12 noon.
Yes, and we filed a second one at 2:30 p.m. That's the one I'm referring to.
All right, hold on. Let me walk with you.
Show me the first one. The first one. Show it to me.
Are you referring to the affidavit of Pumaya Farida Nantoma?
No, the same Mary Wendy Yeboah. There's one filed at 2:30.
Mr. Sorry.
Yes, ma'am.
Your affidavit filed on the 15th of March was filed at 2:30.
Yes,
Is that the one you are referring to?
Yes, my lady. So after the withdrawal of the first one, we then filed one immediately.
Mr. Sorry.
Yes, my lady.
On the 15th of March, you filed an affidavit.
Yes, my lady.
On the 2nd of April, you withdrew. Let me get my dates right. On the 2nd of April, you withdrew your affidavit of 15th March at 12 noon. Yes. How did you file another affidavit on 15th March after you had withdrawn it on the 2nd of April?
No,
kindly educate me.
Yeah, so my lady will realize that you have referred to two affidavits. One was deposed to by Pumaya. That affidavit, if my lady takes a look at it, there was an omission as to page numbers. And so we couldn't be moving that one because the court wouldn't have the full complement of the affidavit. That is the reason why we...
Hold on. The affidavit of Pumaya is a 5-page affidavit.
Yes.
Each one of them is numbered.
Yes, my lady.
So what are you referring to?
There was an error in the numbering. Yeah,
in the numbering of the paragraphs or the pages?
Including the pages. Once we had a 7-page affidavit, actually.
Yes.
But if my lady looks at it, there are actually 5 on Pumaya's. So,
Mr. Sorry.
Yes, my lady.
The affidavit of Pumaya that I have,
Yes,
is made up of 5 pages.
Yes, my lady.
And each one of them is properly numbered.
Yes, my lady.
What are you referring to?
So I'm explaining that there was an omission on our part. It should have actually been 7 pages. So that is why if my lady now takes a look at that of Mary Wendy Yeboah, we have 7 pages. It was that omission.
So you just said Mary Wendy Yeboah filed. Please hold on. Let me land.
No, I'm not going to say
Mary Wendy Yeboah filed another affidavit on the 2nd of April?
No.
Is that what you're saying?
No, 15th.
15th of what?
15th of March.
How can you withdraw an affidavit on the 2nd of April and file a second one on the 15th of March?
No, Mary Wendy Yeboah's own was filed on the 15th of March, 2024, at 2:30.
Yes.
Very well. Then Pumaya's was filed subsequently, or is the other way around. Pumaya's was filed to correct the error on Mary Wendy Yeboah's affidavit. But each of them raised. So my lady will look at Mary Wendy Yeboah's affidavit and realize that from page 5, that's where it ends.
Sorry.
No, my lady, I've got it right.
You can hear me very well.
Yes, my lady.
You appreciate the pickle we are in.
Yes, my lady.
You filed an affidavit on the 15th of... Please hold on. Don't interrupt me. You filed an affidavit on the 15th of March.
Yes, my lady.
You withdrew it on the 2nd of April.
Yes, my lady.
You filed the second one by Pumaya on the 2nd of April.
Yes, my lady.
So your substantive affidavit before... Please.
Oh, yes, ma'am.
Always wait for me to land.
Yeah, I'm not going to say it.
Your substantive application, affidavit before us, is dated the 2nd of April.
Yes,
and is the affidavit of Pumaya.
Yes, my lady. Yes, but
so why are you referring to?
I got mixed up because I have 4 cases this morning, and I just mixed up my paperwork. I've now got it right.
Listen, let me land. If you had just waited to understand my words, instead of rushing to justify yourself, but you would have admitted that you didn't have a formal notice to object,
yes,
and that your notice to object would be your affidavit, then you can go on to Pumaya's affidavit. So where in Pumaya's affidavit now do we have your objection?
So my lady will look at paragraphs 7, 8 of the said affidavit. Okay, take it. Paragraph 7 says that the plaintiff applicant's first prayer endorsed on the face of his motion paper is modeled up in the difficult to understand prayer to restrain the Speaker and the Clerk of Parliament.
Sorry, hold on.
Yes, madam.
How is that expressive of a preliminary legal objection to move an application to amend?
My lady, it is
a lawyer,
yes,
like yourself, like you found yourself muddled up this morning.
Oh,
yes, you have. A lawyer files. I can see what his difficulty is. When you read, you can see he left out some words. You chose to denigrate that what happened in his expressions by describing it as muddled and confused. And the man now wants to correct himself by expressing it fully. And you say you have a preliminary legal objection.
Yes, my lady.
Where is the legality?
The legality lies in the fact that the motion paper invokes the jurisdiction of the court. And if there is an irregularity on the face of the motion paper, which I am pointing out as the foundation to which I am not accepting what he has found.
No, hold on.
Yes.
Which motion paper?
His motion for injunction.
The man is not seeking. Hold on.
Yes.
Whenever I start, stop.
Oh.
You are going to interrupt me.
Very well.
Then you wouldn't hear what I have to say.
Very well, my lady.
The man's application is not to amend his motion paper. His application is to amend his reliefs.
Very good. And my lady will realize that I'm saying in paragraph 7 that his first relief is modeled up in a difficult to understand.
Hold on.
Design. And there's a second
Stop,
one.
stop.
Yes.
And this is why I'm telling you that the application before us is to correct that muddled up expression. Do you not see that?
And so I'm saying, so my point is that is my objection to it. But
He should not correct himself.
Oh, yes, because, you see...
He should not.
Yeah, there's authority on this from this court on that point. That once there's an objection taken to it, you cannot overreach that objection with a proposal to amend.
Hold on.
So that's all I'm drawing the court's attention to.
Stop there, Mr. Stop there.
Yes, ma'am.
Stop there. We began this morning by my asking, when you spoke about the preliminary objection, I said, did you give a formal notice?
Yes, ma'am.
Hold on. Now, if you had given a formal notice, anyone would have known. But in your affidavit, you only described your opinion.
No, what I found
That's not a preliminary legal objection.
Well, maybe it is not stated that it's stated as an opinion, but what I was stating what I found objectionable about it. And this court has also said that I don't even need that formal notice, that I can get up when he's about to move and take that preliminary objection. Trustees of the Synagogue Church of all nations. And the strain of them from the court that I didn't need.
Mr. Sorry, I'm not impressed by what you are doing.
Very well,
but just finish it.
I'm sorry. So,
finish it.
So I'm saying that
it's not fair to your friend. I don't think so. But you want to do it, do it.
I'm relying on the authorities from this court to take my preliminary objection, that I'm entitled to take it just when he's about to move it.
So just do it.
And my second point is that...
No, what is your first point?
My first point is that...
You have been more muddled up this morning.
Order in court, please. Order.
The plaintiff is not entitled to overreach my objection to the reliefs endorsed on the face of his motion paper on his application for an injunction. Because those reliefs were endorsed on his motion for injunction. And in my affidavit in opposition, I have raised an objection to the manner in which the reliefs are couched.
Hold on.
Yes, my lady. Okay. I just realized
The plaintiff is not entitled to overreach. Please, hold on. Let's have some order. The plaintiff is not entitled to overreach my objection to the reliefs on his application for injunction.
Yes, ma'am.
Because
once I have indicated my objection to the reliefs endorsed on the face of his application for injunction, he cannot avoid the consequences of that objection by filing a motion for leave to amend those reliefs and render redundant my objection.
So you want to be able to dance with your objections. That's all.
as every other counsel and party is entitled to. And the case of Ahinakwa II versus Okaija III makes this point that an application for leave should not.
What's the citation?
2011, one Supreme Court of Ghana law report at 205. My lady may want to look at page 216.
And what's at page 2 and 6?
2 and 6. That an application for leave.
Read from page 2 and 6.
Yes, my lady.
Is it read?
It's a bad decision. That an amendment ought not to be allowed for purposes of defeating an objection to a process. And my submission is that the effect of allowing him to amend is that my depositions in my affidavit in opposition, which contests those reliefs in his on the face of his motion paper, would effectively now be defeated. That is the point that I'm making. And my lady, the case of trustees of the Synagogue Church of All Nations, 2010 Supreme Court of Ghana law report, quotes a string of authorities which say that I am entitled to give a notice, formal notice of objection by way of an application, or raise it at a point when he's about to move his motion, since it is a point of law. But my lady, I take cue from the point that you've made that maybe next time I should give him formal notice. But I thought, no, the court says I'm entitled to do the two. But if the court now prefers that we should do one, I'm guided by the court. But I'm guided by the previous decision of the court, which establishes my point.
Round up.
My lady, I pray accordingly.
I just beg you of you to actually make an observation on the procedure adopted by my late friend, counsel for the first defendant. But I think the more fundamental question, respectfully, is whether counsel for the first defendant is actually justified in withdrawing an affidavit that he has filed in the matter that has been served in the parties without leave of the court.
Respectfully, Attorney General, let me deal with the matter on hand, and then I'll come to your own, because yours is different.
But because he intimated that his objection is contained in paragraph 7 and 8 of the affidavit, which respectfully I seek to appeal. That is why I'm raising the point.
He claims his objection
is contained in paragraph 7.
hold. Can I finish my sentences? He claims his objection is premised on paragraph 7 and 8 of Pumaya's affidavit, which was filed on the 2nd of April. He is not referring to the affidavit that was withdrawn, which was filed on the 15th of March.
Right. My lady,
so if you don't mind.
My lady, respectfully, when this affidavit was filed on 15th of March.
Yes.
And the second one, the corrective affidavit, respectfully, was the one filed on 2nd April.
Yes.
2024.
Yes.
And respectfully, that same point is contained at paragraph 7 and 8 of the new affidavit, which now he seeks to proceed on.
Yes.
And that's why, respectfully, I was making the point that even his own procedure, respectfully, is flawed. Because he cannot, on your own, file an affidavit, have it served in the parties, and within a lapse of about 2 weeks, subsequently, on your own, without any leave of the court, withdraw that affidavit. And then again, without leave of the court.
So, Honorable Attorney General, I intend to listen to you before we rule. Thank you. Mr. Abedu.
Lady, I'm grateful. Lady, with the greatest respect, my response will be only one. I rely on Order 16, Rule 7, Sub Rule 1 of CI 47.
Order 16, Rule
7, Sub Rule 1 of CI 47.
Which reads,
with your kind permission, that for the purpose of determining the real question in controversy between the parties, or of correcting any defect or error in the proceedings, the court may, at any stage of the proceedings, either on its own motion or on application of any party, order any document in the proceedings to be amended on such terms as to cost or otherwise as may be just, and in such manner as it may be direct. So, milady, with the greatest of respect, our position is that
Yes.
the step adopted by us in filing a motion for amendment
Yes.
is very much warranted by the rules of court.
You mean it's supported?
Exactly. And my lords, we've not done anything untoward. I submit accordingly.
Yes, Attorney General.
Especially, my lady, indeed, a step in correcting any process or any error in the proceedings, respectively, ought to be done only with leave of the court. And that, indeed, has been pointed out graciously by counsel for the plaintiff, Order 16, Rule 7 of CI 47. Counsel for the first defendant indeed sought to correct what he considered to be a defect with this affidavit by, without leave of the court, filing a notice of withdrawal.
So it's counsel for first defendant who has done the wrong thing.
Precisely, respectfully. And I think, with all respect, having not complied with the rules, does not, with all respect to him, he's my very good friend, have any basis at all for complaining about a defect in the process filed by the plaintiff, which does not exist at all. And I respectfully submit that the affidavit filed by my late friend on 2nd April 2024, without leave of the court, is offensive to the rules of the court, and indeed will have to be struck out. I did not want to interrupt his flow. That is why I reserved my submissions until after he had concluded. Secondly, respectfully, I did not see, with all respect and in all fairness, any defect or error at all.
Hold on, AG. Yes.
My second point I make respectfully is that I do not see any error in procedure adopted by counsel for the plaintiff in seeking leave of the court to amend a relief contained on an earlier motion filed by counsel. And indeed, a close look at the relief sought by the plaintiff in the amendment before you shows no material difference from the reliefs originally sought. In fact, the second relief is actually the same substantially as the second relief originally sought. And the first relief only seeks to correct an error in the formulation which doesn't go to the substance of the relief. Is that what they say? That being the case, respectfully, I do not see any injustice that will be caused by a grant of the application for amendment. I pray accordingly.
But if may please, about just small points.
Please sit down.
Yes. Yeah. I just wanted to make it.
Please sit down.
Very well. But I think
Please sit down.
Very well. Because
Please sit down. So, Mr. Sori, you have indicated that you want to respond to some points made. I don't know whether the point made by a point made by the Attorney General or a point made by Mr. Bidu. But before you do that,
yes,
I want you to respond to the more fundamental point,
yes,
of whether you acted offensively by raising this, your objection, on the basis of an affidavit that was filed without leave of court. I want you to respond to that.
Oh, yes, that's actually what
I can imagine. I want you to answer that first.
Because, Maliri, there are two ways by which a party can withdraw a process before the courts. With leave or without leave. And when a party is insisting on their pound of flesh,
like what you are doing this morning.
Yes. You must base it on an authority of the court or some rule of practice. And that's why we as counsel, we cite authority for it. But just making a sweeping statement that I ought to have filed, I ought to have sought leave of the court before the withdrawal, does not satisfy that point. Once there's a right to withdraw with or without leave, he ought to have drawn the court's attention to the fact. But to give the impression that I'm not entitled to do it at all, I disagree with that position. And that's the right position of the court, even by reference to the High Court rules that my friends have relied on in the Supreme Court, which has its own rules, without invoking the court's powers under Rule 5 or 7 or so to supplement the lacuna. But also I'm saying that that argument that I acted offensively doesn't arise. Secondly, the two affidavits I have filed only become relevant at the time of the hearing of the substantive application, based on my citation of the case of trustees of the Synagogue Church of All Nations. It is clear from the two affidavits, even if the court takes the view that one was offensively or purportedly withdrawn, the second one or the first one still contained the same objection. So he should have waited. I think he's overshot the runway. Maliri, then the most important thing in the learned Attorney General's submission, and let me corroborate his point that he's my very good friend, is the attempt to even say when the plaintiff has admitted that there is something wrong with his motion paper, he still takes the view that there is nothing wrong with the motion paper. Because by the very motion they have filed to amend, what I'm saying is that the plaintiff himself has seen the problem based on the objection and has filed a motion. Yes, my lady.
Listen. He says there is no material difference between the original relief,
yes, my lady,
and the amendment sought.
Good.
The error only seeks to correct an error in formulation.
Very good. And my lady,
that's all he said.
If there is no material difference, there is no point in the application. That's the point. There's no material difference. Yes, my lord. So
can you resume your seat? Kindly resume your seat.
Which actually deals a blow to the application.
Kindly resume your seat. By court, our considered view is that the alleged preliminary objection is unnecessary and does not seek to assist any process before this court. Every party has an inherent right to present the appropriate formulation of their reliefs or other process before the court to enable the court to determine the real matters in controversy. The objection is dismissed.
As the court pleases, Fali.
You've taken our time and energy for nothing. Now, so, Mr. Abedu, move your application.
Lady, I'm grateful. Lady, respectfully, before you is an application or notice for leave to amend the reliefs on the motion paper for an order of interlocutory injunction filed on the 7th of March 2024. My lords, I move in terms of the motion paper and the supporting affidavit as well as the annexure Lady, there was a patent omission on the motion paper in respect of our application for interlocutory injunction. And, Lady, we have stated the right formulation.
So which is this, what is this omission?
Lady, the omission was that...
What's different here from what's the original?
Yes.
You've attached a proposed amended motion.
Yes, we have.
Yes.
Lady, there were patent omissions.
Please, yes, point it out.
Yes, and milady, this is where in our motion paper we have stated the actual thing, that an order for interlocutory injunction to restrain the Speaker and the Clerk of Parliament of Ghana
Mr.
Yes,
I think my lady is asking you to point out the omission in your
motion
original
paper. Very well.
process. That is what she's asking you to.
Very well. Lord, I'm grateful. Lady, at paragraph 3 of our motion paper,
I think that the only difficulty is what Mr. Story has described as muddle. The words for his assent from presenting to the president, for his assent from the Attorney General, from assenting.
Exactly.
Is that not it?
That's
what you are seeking to delete.
Exactly.
So, I mean, what's so grave is my question.
Lady, precisely the point.
You want to present a more elegant formulation that does not have any muddled words.
Exactly. Milady,
yes.
Very well. Milady,
are you done?
Milady, this has been stated in our proposed.
Please hurry up, but we have a very full day.
Very well. Lady, all said and done, I move accordingly.
Thank you. Mr. Sorry.
The ruling of the court in the preliminary objection actually dealt with this part. Because my lady said that...
You could just have waited.
A party is entitled
to... It's okay.
to...
You have nothing to say.
Very well, my lady. And I thank the court
Mr. Sorry has nothing to say.
I thank the court for using my words to point out what he should have done.
Yes, Attorney General.
Lady, indeed, I'm not opposed to the application. I think it just needs to correct tautologous formulation. Or just some tautology in there. That's all.
What did you say?
My lady, I think my dear friend actually sought to correct a tautologous formulation. So if my lady...
I didn't know this rendition.
Yes.
Tautologous.
Yes. Because really, my lady, if you look at it, it says, another of interrogatory injunction seeking to restrain the speaker from presenting to the president for his assent through the attorney general from assenting to the human.
So that's where the tautology is.
Precisely.
Which is tautologous.
Precisely.
Yes, definitely clearer. Are there any, so by court, the applicant is granted leave to amend his application within the terms as sprayed by close of day on Thursday, 9th of May, 2024. Are there any other fundamental matters that we should deal with?
Lady, our second application, respectfully, is not before the court, so we don't know whether we can speak to same.
You have another application?
Yes.
What is that?
Lady, that's what I pointed out earlier on.
Please speak into the microphone.
Lady, that's what I pointed out.
Are you not ready? If you're not ready, don't come to court.
Lady, we have that motion on notice for leave to file supplementary affidavit in support for application for...
And why is it not before the court? Because you filed it yesterday.
No, we filed it on the 8th of March.
So why is it not before us?
Lady, we are equally surprised.
I beg your pardon?
We are equally surprised that it's not in your document.
Do you have it? Okay. You have it. My colleagues have it, so let's go on. Move it.
Very well.
Please move it.
My lady, I thought that since he has admitted that it was belatedly filed. When?
Filed it on the 8th of March.
We haven't.
I hadn't seen it on mine.
The court, it is well.
Can you allow me to manage my court? Mr. Sorry.
I apologize, my lady.
Mr. Bedun, because of the nature of your amendment, which doesn't really go to the root of anything, of your reliefs, it's just a better formulation of it. I think you should move your application to file the supplementary affidavit so that we can get it out of the way as well. Why is there a need for you to file this supplementary affidavit?
Lady, we have deposed at paragraph 6, 5 and 6, actually, of affidavit in support that there was an inadvertent omission on our part.
Mr. Bedru, what is this business of referring to things without saying what exactly what's salient facts?
Lady, we're saying that in our...
How can I exercise my discretion when I don't know what you want to do?
Lady, we've indicated so in our proposed attached to the application. And particularly, paragraphs 4, 5, 6, 7, 8, 9, and 10.
4 says that...
That's 4 to 10.
4 says that the bill prescribes custodial sentence as punishment for any violation. You need to put that into your statement of case. That's what you're saying.
Exactly.
5 says that nowhere have these persons indicated they are acting for and on behalf of the president. Who are these persons?
We are referring to the private members who introduced this bill.
But it's inappropriate to refer to the private members in these words. These persons. Is it inappropriate? I can't give you leave to put this in an affidavit.
Lady, I'm grateful for the cue.
And then you say, therefore, for members of parliament who are not cabinet ministers to place this bill before parliament, it is constitutionally flawed. What does that mean? Could you ensure that if I give you leave, you articulate it so your friends are ready?
Very well.
Then the next paragraph is which one?
Ladies, 6, 7.
6 and 7?
Yes.
I must say that I have a difficulty with your language and the language of the affidavits of Mr. Sorry. I mean, I was going to come to that. I mean, some of the language is intemperate. We were going to deal with it. Mr. Sorry, you can sit down. Some of the language in your affidavit is intemperate. So please employ more courteous language. In the same way as I'm going to tell Mr. Bedru to watch his expressions. Just say yes, thank you.
It's the temperature.
Mr. Bedru, you can come back. Mr. Bedru, you might come back on your feet. Seven. You see, please avoid the presentation of essays. Be specific. What do you mean by indeed grave? Grave is not a principle of law. It's not a precept. It's not a doctrine. And therefore, your articulation should direct the advocacy. So, as much as we'll give you leave, it cannot be in the words you have presented to us.
Very well.
And verse 8, look at me. Paragraph 8. Yes.
Lady, do I read with respect?
Paragraph 8.
Yes.
You say that the instant action is premature. Is that what you're saying? Mr. Sky, Mr. Abedu,
Yes, milady.
You say that any argument that the instant action is premature has no basis, simply because the bill has been passed by Parliament and is awaiting presidential assent. There's no better time than now for the plaintiff. Please upgrade all your expressions into legal, because this affidavit, whose affidavit is it? It's an affidavit of Mr. Sky, who is a lawyer. All right?
That is so.
Thank you. I'll listen to you, please. So Mr. Abredu moves his application for leave to file supplementary affidavit.
Exactly so, my lady.
All right. Attorney General, I think I should listen to Mr. Sorry before I listen to you. Mr. Sorry.
My lady, we would not oppose it. I was going to make a proposal subject to the convenience of the court that if you look at the nature of the amendments that are sought by my learned friend, in one breath, he has leave to file just an amendment to his motion paper. So we're going to get an amended motion paper, a supplementary affidavit. If he just filed a fresh motion so that we just respond to it once and for all, maybe it will be more convenient. Because referencing, I got to realize this morning that when you have too much of it on your desk, it can create problems. If you would just file a fresh one, put his supplementary and all of that into it, we'll respond to it and we'll be here. That was the proposal I wanted to make. So they consider it to be tidier and neater for everybody.
Thank you. Yes, Attorney General.
I was actually going to oppose this application. It offends every rule regarding affidavit. It is argumentative, it's offensive, it doesn't contain any facts at all. The rules governing affidavit are that you depose to only facts and not law. Essentially, the argument here, argument of law. And I think it's very much offensive to the rules governing affidavit. Secondly, as my lady pointed out earlier on, the language is intemperate, and for that matter, it again offends the rule regarding the avoidance of scandalous affirmation or depositions in an affidavit. But I think that the affidavit, with all respect, is unnecessary because the essence of his case has been made out in the original affidavit filed. This affidavit which only seeks to add onto it through matters which essentially are matters of law and also are scandalous, ought not be permitted. I am really, with all respect, a stickler for rules. That is why my affidavit, if it's not of fact, I do not really depose matters. They must be matters of fact. If they are not facts and they are matters of law, they ought not be countenanced in an affidavit. Secondly, they are also scandalous and they are irrelevant. I think if it's going to...
Give me a minute. Yeah?
Right.
So the averments proposed in the sought for supplementary affidavit do not speak to facts.
Respectfully, that's true.
The language is intemperate. That I will not note down. Go on.
Right. And respectfully, I am supported by Order 20, Rule 8 of CI 47. Indeed, CI 16 has no provisions on affidavits. The only provision on the content of affidavit is as contained in Order 20, Rule 8 of CI 47. And it stipulates that an affidavit shall contain only facts that a deponent can prove. Respectfully, there's no room for matters of law. And I think that, indeed, this affidavit, to the extent that it doesn't bring any new fact, doesn't state any fact at all, ought not to be allowed. Secondly, Rule 9 of Order 20, CI 47, again, says the court may order any matter which is scandalous, offensive, irrelevant, or otherwise oppressive to be struck out of an affidavit. Respectfully, all the matters here are very much scandalous. In terms of the use
You've already said so.
Precisely. And I think that the affidavit, indeed, my friend has the opportunity of filing an affidavit together with the motion that the court, I'm sure, has already granted leave for him to amend. And he can state it. But of course, he must be cautioned that it cannot be the insertion of any scandalous or argument of law. I pray accordingly.
Oh, just. My lady, very small point.
I will notice you very soon.
I'm most grateful.
Mr. Sorry, should I listen to you? You'll be speaking out of 10. You've already had your opportunity.
My lady will realize that because of the difficult position in which the Attorney General has put me on one occasion.
He's pushed you?
Yeah, he's put me because if on a point he aligns with the plaintiff, it will usually be better for me if the two of them will take
I beg your pardon. Nobody needs to align with anybody.
No, there are times when he took a position against me.
Mr. Sorry, I beg your pardon. I beg your pardon.
Very well. Let me move on from that.
If you have nothing to say.
No, I have something to say against the submission that you made. Which is that, based on the practice that we all took you from in terms of the court's direction, the Attorney General filed no process indicating his objection to what is scandalous, what please matters of law this morning, in order to enable us all prepared to come and take this point.
I beg your pardon.
There's a second point.
I will not note you down. Thank you.
There's a second point. The second point is that apart from saying they are scandalous and all, which are the words that are scandalous, which ones plead matters of law? So if my lady would, or if the court would exercise its power.
Can I manage my court?
Oh, I was just making a submission.
Can I manage my court?
Very well, my lady.
Thank you.
Well, I was just making submissions to assist the court.
Order in court, please. Order.
By court, after listening to all counsel, the court agrees with the suggestion of counsel for first defendant and orders the plaintiff applicant to file a fresh motion paper with supporting affidavit and statement of case. Plaintiff is also given leave to address any matters of fact and issues of law in the new process. Plaintiff applicant is given up to 17th of May. So now you have moved from 9th to 17th of May. Up to 17th of May, 2024 to further new processes. Counsel for defendants are given 7 days after service on them to file any processes that they may wish to. But
I'm proud just to point out that he should address new matters of fact in the affidavit, not issues of law. Respectfully, that would be offensive of the rules. Affidavit contains matters of fact, new matters of fact.
And I said so.
No, it said and new issues and issues of law. I heard.
Yes.
No.
I said matters of fact.
Yes.
And issues of law.
No,
that they want to.
Right. Because
I don't want any further applications.
No, because issues of law cannot be an affidavit. So
no. Listen.
Right.
Listen. I don't know if you listened to my ruling.
Yes.
I said the plaintiff applicant is to file a fresh motion paper with supporting affidavit and statement of case.
Oh, statement of case. Right.
Yes.
That's fine.
That's part of the ruling.
That's fine.
If you missed that.
That's fine. Yes.
This is why I said he may introduce any new issues of law, because I'm not going to give you any new, I'm not going to listen to any further applications for amendment. So just do a good job. And let everybody say what you want to say. But I think it's necessary to say this. Mr. Sorry, some of the material in your affidavit is extremely intemperate. I know they are not your affidavit, especially the affidavit of Mary Wendy Yeboah, which you have now withdrawn. do well not to introduce such material.
I'm most grateful, my lady.
Thank
Sometimes you respond to what comes from the other side. And that's the reason. But I'm taking cue. When they take a shot at you, you throw something back.
Yeah, really, it is. Attorney General, kindly resume your seat. There's something I want to say to you too. Ms. Attorney General, you didn't file any process in this one.
Indeed, I filed an affidavit in answer to the application for secretary injunction.
When was it filed?
It was filed on 25th March 2024.
Thank you.
All right. Okay.
Please give me a minute, sir. Attorney General, please remain on your feet. Yes. Did you want to say something? Attorney General, look at your original paragraph 8 of the affidavit in answer by Nana Kunedu Frimpong. You state the issues, 3 issues. What's your position in relation to them? So this court is directing you to state what your position
in a statement of case.
In the statement of case.
Hey, that's right.
And so that you don't surprise anyone.
But that's right. But that's because, as I said, I stick to the rules.
Yes, but the rules require you to file a statement of case. But
now the court has already statement of case. I'll file statement of case.
Are you going to file a statement of case?
You have ordered out.
If you don't file a statement of case, I will not let you
be heard. Yes.
Argue any points of law.
Yes.
I will not hear you.
Yes. The court has now ruled a file case, so I'll file. Otherwise, I only have said the law in an affidavit. No.
And you were required to do so in the statement of case, and you did not file any. You've been given reprieve now. You now have time.
But the rules of the Supreme Court, respectfully, do not require the filing of a statement of case in support of an application for injunction or opposition, unless the court orders, and the court has ordered.
Attorney General, yes, you may do what you please. No, you may do what you please.
I'm only stating the true position of the law. That it is only in the High Court that statement of case is filed, but unless the court orders, which the court has ordered.
And Attorney General, if you do not want to file any statement of case, that is your option. But I will not hear you.
No, my lady,
I'm just informing you. I will not hear you. May I have the last word? Thank you.
No,
good morning. Suit is adjourned, Sanida. You have another.
Well, we are grateful for your indulgence. The series of amendments proposed by my friend and all. Even though I'm not for him.
Respectfully, my lords, writ number J1/13/2023, Dr. Amanda Odoy versus the Speaker of Parliament, the Attorney General. Are you Dr. Amanda Odoy? How's your name? Please, can you remove the mouse and then speak? Can hear? Yes. Andrew Kwaku. About representing the plaintiff. The Speaker of Parliament. Lord Edwin Tufo. Legal officer. Lord, the second defendant, Attorney General, is present.
Does the plaintiff have counsel?
May it please the court, Dr. Ernest Akun, with Benedict Nikraku for the plaintiff applicant.
Dr. Ernest Akun, is that ARKO?
Melody AKO.
With
Benedict Nikraku, Ni-Kraku.
Yes.
It may please the court that you sorry for the first defendant respondent. With me is Raphael Banangwin.
If you please the court, Godfrey Yeboah Dame, the Attorney General, appearing with Dr. Sylvia Adusu, Chief State Attorney, Mrs. Vivienne Opoku Ejakwa Adusu, Chief State Attorney, Mrs. Vivienne Opoku Ejakwa, Principal State Attorney, and George Saki, Principal State Attorney. The second defendant.
We have before you a motion for interlocutory injunction. Lady, we have a difficulty. Lady, on the 22nd of March 2024, the first defendant respondent filed an affidavit in opposition. And then on the 30th of April 2024, they filed a supplementary affidavit in opposition without leave of the court. And lady, a very close look at the supplementary affidavit strong language and statements that are prejudicial to the case of the plaintiff applicant. And Lord Melody, we feel that we should be given an opportunity to respond. Lord, especially when in paragraphs 12, 14, and 20, there are allegations of collusion, lack of candor, suppression of facts. Lord, these are very strong
statements that we think we should be afforded an opportunity to respond.
You say you want to respond to the affidavit that he has filed without leave.
Yes, my lord.
He has filed a supplementary affidavit without leave.
Yes, my lord.
And we want to respond to the contents of that.
Let me understand you better. Do you want to respond to the language, or you want to respond to the content?
That is not the language. We are not going to.
So regarding the language, what are your submissions?
Lady,
Since you've referred to them.
Lady, our submission is that the language is scandalous and ought not to stand.
So if it's scandalous, ought not to stand, what do you want?
Lady, we want either the court strikes.
You either say something or you don't.
Lady, we are saying that the court should either strike it out or the first defendant does the honorable thing.
Are you going to finish your sentence?
Lady, I'll finish by saying that he does the honorable thing by either withdrawing the supplementary affidavit or taking steps to correct what is not supposed to be in there.
So now you don't want the leave to respond to it.
You see, Dr. Akum, if you want something in court, you must present it the way we do. If you have an objection, say so. Tell us what you're objecting to. Tell me what you want me to do. Then I can do it. But it's inappropriate to get up and just make comments and sit down. What do you want from the court?
My apologies. Lady, what we want from the court is that the supplementary affidavit filed on the 30th of April was done without the leave of the court. That sins against the rules of court.
Which rule?
My Lord, there's a case law.
Which rule?
Lord, I'll go to a case first.
All right.
But Order 20, Rule 9 of the CR 47.
Hold on. You know we are not in the High Court.
Yes, my lady.
It was filed without leave of court.
Yes, my lady.
And you rely on Orders 20.
My Lord, we'll first cite the case of Nana.
You rely on Order 20.
Lord, we are relying on the case of Nana Kusia Jimai.
Are you abandoning your reference to Order 20?
My Lord, my lady,
You cannot start and stop.
Yes, my lady. Lady, I'm sorry, but Order 20, Rule 9 is on the scandalous nature of the affidavit.
And yes, and so?
So that is Order 20, Rule 9.
Let me tell you what I've got here.
Yeah.
We have an application for interlocutory injunction. The first defendant supplementary affidavit of 30th April 2024 was filed without leave. And we rely on
The case of
you rely on
the case of Nana Kusia Jimai.
Nana
Akusia Ajiman versus Trustees Synagogue Church of All Nations. There is Civil Motion J8/30/2010.
My lady, it's 2010 Supreme Court of Ghana Law Report. I think I recall that it's on page 707 thereabout. I was just trying to assist. I'm my assistant friend.
Yes, you rely on that to make which point?
On this case?
Yes, to make which point?
Yes. And so the point we're saying is that he should have come to the leave of the court. He hasn't done so. And the statements in there are prejudicial to the case.
No, you're jumping. Do one thing at a time.
Yes.
You said he filed it without leave of court.
Yes.
You rely on this case.
This case, yes.
To read the
case, the case is to the effect that...
Read the ratio that you are relying on.
My Lord, I don't have the case.
Then how can you cite a...
My Lord, I know it.
Can I finish my sentences?
Yes. Very well, my lady.
If you're not prepared, don't stand up and make a point.
Lady, I'm sorry.
Yes, because you had all of this before you came here. And you stood up to move your application and decided to make a point. So why are you not prepared? If you don't have your authority here, then I'll discard it.
We have the authority.
Go on. Pardon me?
We have the authority here. Lady, the authority is to the effect that they should have come by a motion of notice, and they have not done so.
They should have come where?
They have come to the court formally to seek leave before filing the supplementary affidavit, which they have not done.
So what do you want me to do?
So we are asking for an opportunity to respond to...
How do you respond to something that is incompetent? That is inherently flawed.
Order in court, please. Order. Order in court. Order in court, please. Order.
Ladies, so our first point is that it should be struck out, but if they want to leave it in, then we want an opportunity. Ladies, then we are asking that it should be struck out.
My lady, we are vehemently opposed to the application, and we have just 3 short grounds upon which we are opposed to it. The first ground is that the trustees of the Synagogue Church of All Nations case, on which he relies to make his case. No, he wanted the citation. He didn't have it. So I just gave him the citation. So I'm well versed with it. And my submission in response is that it says nothing close to what he says in this court. There's no issue there about the supplementary affidavit.
You led him into temptation in order to shoot him down?
No, he was walking into his own temptation. It says nothing close to that. The case had to do with the manner of raising preliminary objections in this court. And the court considered Rule 5 of the rules of the court and then distinguished between...
Read the relevant.
Oh, I mean, Just a second. That is a not very long ruling, but the first sentence says this. A rule of practice when declared by a court of competent jurisdiction must be followed until that court has a higher court has declared it to be obsolete. And I'm going to explain why the court said it in this context. That once it comes to preliminary objections, the long-standing practice
from the law report.
Malady, there are about 3 holdings. That's
read all the holdings.
Oh, very well. When a preliminary objection had been raised to a motion, the grounds of the objection shall be apparent without recourse to the affidavit or supporting documents. If that could not be done, then the preliminary objection would be improper. That rule was, however, subject to the operation of Rule 79 of the Supreme Court Rule CI 16 dealing with non-compliance. Thus, whether a breach of a rule of practice should be held to be fatal or result in proceedings being set aside as irregular or waived would depend on the circumstances of the case. Prejudice to the other side being crucial, and that's what I'm going to refer him to in my next point. And where a jurisdictional point was involved, as in the instance case, a breach of the rule of practice or procedure could hardly debar a preliminary objection, notwithstanding that evidence might have to be called by way of affidavit or otherwise. In the instant case, the notice of preliminary objection in the affidavit of opposition went to the jurisdiction of the court to entertain the applicant's motion for stay of execution, and did not matter that it was based on the position as to facts. The respondent's preliminary objection could not, therefore, be said to flout the rule of procedure related to the raising of preliminary objections to motions. Per curiam, the legislative mood of the Supreme Court, 1996 CI 16, towards non-compliance. Malin, should I go on?
No.
It has nothing to do with it. So, first of all, yeah. Oh, well, there are a few more. There's a second point. I said there were 3. The second point is that my friend gets up to just make sweeping allegations against me that the affidavit contains scandalous material and makes reference to paragraph 12 and a number of them that I can't immediately recall. But it is important if this court would have to agree with him for him to tell me which one he deems scandalous. When I say, looking at the nature of the affidavit filed by the Attorney General, it appears to align with the case you have been making in this court. And so I have even indicated in the supplementary affidavit that at the hearing of this application, I'll be seeking leave of the court to have this supplementary affidavit admitted. And so, insofar as the application is concerned, even if it were proper, he needed to indicate to this court which part was scandalous, so that the court will exercise its discretion to find out whether it is really scandalous or otherwise. My lady, given the deposition that we have made, that is to ensure expeditious trial. Disposal of this case. If we had filed a motion for leave, the court would have granted leave, would have, or otherwise, then would have had to come back. So at the hearing, I've indicated that I will be seeking leave of the court. So it aligns with the court's own duty to ensure an expeditious disposal of the application, if this matter is brought to the attention of the court at this stage, to make the order. And in any event, like the trustee's case that he cited, without getting to the point that he should have gotten to, he has improperly. My lady, I'm most grateful.
But just regarding the point of leave to file supplementary affidavit, respectfully, I consider it to be well established in the practice of this court that when an application has been filed or when an opposition has been raised in the form of an affidavit, further filing of an affidavit in the matter has to be with leave of the court. But I think that is well established. I'm really at a loss as to why my raising issue with that practice. Otherwise, a party will have unrestrained liberty to be filing processes in the matter, even after the other side has responded. The Attorney General filed an affidavit in answer to the application on 16th April. And respectfully, if indeed another party can, after a motion has been fully considered for hearing, be filing without leave affidavits in the matter, I think that it doesn't augur well for good practice. That is my response. So I would think that in accordance with what the subject practice of the court, a supplementary affidavit has to be with leave of the court. Regarding the matter of whether the content of the affidavit filed by the first defendant is scandalous in some part, I myself have actually noted some paragraphs in his original affidavit which are scandalous, and I was going to raise it. I've noted it here. This morning I noted it even before I came. And I also find that some of the paragraphs, with all respect, are also argumentative. They argue only points of law, which again offend the rules regarding affidavit or content of an affidavit. But I don't know if the court would like me to proceed to point out the paragraphs in his original affidavit which are scandalous, or I should
No,
wait.
you are on your feet now because you are responding
the supplementary affidavit.
Yes,
that's fine.
You are responding to the submissions
whether there has to be leave
of Ms. Dr. Akun.
Thank you very much.
Not your own submissions.
Madam. Yes, madam.
Ready for you.
Yes, because the Attorney General.
I'm not ready for
Very
you.
well. I just wanted to bury a
No,
point
I'm
of
not ready
proceeding.
for you.
Very well. Because when you say well-established practice, you must substantiate it with something. Very well, my lady.
You indicated that you had, it was part of this supplementary affidavit that you would pray the court to admit it. Which paragraph is that in? That's what I was looking for.
Paragraph 21.
21.
Yes, madam. And this is.
Hold on. I asked for. Mr. Sorry.
Yes, my lady.
You did not say that you would pray the court to admit it.
I didn't use the word prayer. I said the court should admit it at the hearing.
You said it is important that the first defendant instant supplementary affidavit be admitted. It's important to who?
To the first defendant, because we have filed it. It must be.
So if you want to pray, say so.
Very well. I apologize. But I've given an indication that I will want it admitted at the hearing, and I'll just give that indication. I apologize, my lady. I'm learning some of the legal things that I should use to properly prick the bosom of my lady to apply the law in my favor. Prayerfully.
Beg your pardon.
I say prayerfully. Making the application now.
For the admission of your supplementary affidavit.
My lady, yes. It was in accordance with that I wanted to respond to the Attorney General's.
I thought you would end your response with this.
Very well.
Since there was no humility in your response.
Which one is that? This one that I prayed, my lady, that the court should.
You had to go around before you found your humility.
Because I didn't respond to the letter of Attorney General's accusation. That's the reason that I will leave it there.
Mr. Sorry, the court must make clear to you that apart from the fact that it was procedurally wrong for you to file this supplementary affidavit without leave, the court had reservations about much of the language in the affidavits of your deponents, which carry the stamp of your law firm and your name.
Oh, is it?
Each of these affidavits has your name at the bottom.
Yes, my lady.
For instance, in the supplementary affidavit, this use of the language have deliberately, which paragraph is it? Have deliberately, paragraph 12, have deliberately suppressed the fact that the concerns raised by the letter which they flaunt before the court is intemperate. No, hold on, I'm not done at all.
Yes. My lady,
Paragraph 14, accordingly, it is plainly lacking in candor. There's just too much of it. When you go to the original affidavit by this second one is by Nestina Brokwa. The first one by Mary Wendy Yabua.
yes, ma'am.
That was very difficult to read. You're a very senior lawyer.
Yeah, my lady.
Mr. Tink. You're a very senior lawyer. What is particularly despicable and a definite desecration, you can hear me.
Very well,
Unless you want to do this. But I'm sure, that's why I say you're a very senior lawyer. Mr. Sorry.
Yes, my lady.
Unless you just want to be insulting in affidavits. If that's
not at all.
If that's what you want to do,
not at all.
You can tell me you will not withdraw it, and then I will give a ruling. But please listen to me.
Very well.
I think that the language is intemperate. A lot of the paragraphs contain language that's inappropriate, scandalous. So I want to give you directions.
Very well. My lady, I'll go with the directions of the courts. The point I wanted to make was that each of these, maybe it was strong language I used given the circumstances, but a reading of the affidavit would reveal the reasons for which I make those statements. And so I'm guided by the courts.
As Attorney General,
so if I say...
As Attorney General has indicated, it's argumentative. You see? So if you have points of fact, state them.
Oh, my lady, yes.
But these kind of opinions, these kinds of descriptions, these kinds of references, I think you need to review it.
My lady, is coming from the court, but if we were to go...
I'm not going back to the Attorney General.
Because
no, hold on. I'm not going back to that. That's why I've chosen to speak with you.
Very well. So I just want to make a small point, which is that, my lady, in the well-established practice of the court, as the Attorney General has pointed out, we would say, I'm advised by counsel and verily believes him to be true. And the point is made there.
Mr. Sorry, are you going to be guided by me?
That's what I said.
Then kindly sit down.
Very well.
By court, the court is of the view that several paragraphs of the affidavits of the first defendant's deponents contain language that is intemperate and inappropriate. First defendant is directed to refile a fresh affidavit raising all matters of facts that they wish to bring to the attention of the court and any other process that they may deem relevant.
Most grateful, my lady. Yes, my lady. We'll file within 7 days.
No, my lady.
Sergeant Sanida.
But you are grateful.
Lady, respectfully, do we have an opportunity to respond if they file? Yeah. Very good. No. My lady, there is an affidavit in opposition already. Sitting by him. My lord, if he seeks the help, and ask the director. I'm seeking that. Yes, my lady. My lady, the point I'm making is that he has an affidavit in opposition already, and this one is a supplementary one.
Order in court, please. Order in court, please. The panel will be reconstituted. All rise. Please, you may resume your seats. Kumi today.
And that was Justice Tokono, the Chief Justice, who has just adjourned the case of Amanda Odoi indefinitely. Earlier, she adjourned the case of Richard Sky, also Senedene, and you've seen the arguments between the lawyers of the Richard Sky and also lawyer for Amanda Odoi. You've seen lawyer for the Speaker, and you've seen the Attorney General, all of them arguing their cases, and you've seen the banter that went in there. I mean, the case has now been adjourned because the Speaker earlier there was an objection to an application to actually amend the release, which was objected by the Chief Justice, and then later granted that application for the release to be amended. Then finally, Chief Justice Okono adjourned that case, which was filed by Richard Sky. Then we opened the case of Amanda Odoi. You've been following that conversation in the Supreme Court. It has been adjourned indefinitely, and there is more we'll be bringing your way in our subsequent bulletins. And the midday news comes up in a bit. We'll bring you more of this. You can also go to myjoyonline.com. You'll get more of the proceedings in court today.